Good evening, everyone. Thank you for joining us tonight for this webinar. Tonight, we're going to hear from Elissa Taub, immigration lawyer and partner at Siskind for the webinar Physician Immigration, Everything You Need to Know About J-1 Waivers. I look forward to introducing Elissa in just a few moments. Please note that tonight's presentation will be recorded. While everyone's still logging on, I want to take a moment to introduce myself. My name is Ashley Pichard, and I'm the Program Relations Specialist here at Practice Match. Hopefully, since you're here tonight, you already know about Practice Match and all that we have to offer physicians. If not, I do want to highlight a few of the resources my team and I have available to make sure you get the most out of your Practice Match experience. First, we have the free CV builder and free expert CV review. We have scholarships, a job board where you can see postings and filter them by specialty, geographic location, visa status, and more. You can create a profile and fill in your preferences so we can notify you about jobs that come open that match what you're looking for. We have virtual career fairs to connect you with employers hiring in your specialty. You can earn some additional revenue during training by attending them, and even more additional revenue by becoming a physician promoter and encouraging your colleagues to attend. We have free monthly webinars on various topics regarding training, interview preparation, contract negotiation, immigration assistance, loan repayment, and more. And if you think your program would benefit from a personalized training on any topic mentioned above, we can do that too. We have a free physician immigration handbook provided by Siskind. We're very happy to have one of the authors as our presenter this evening. We also have a network of experts in just about every physician-facing industry. So if you ever have a question related to career guidance, you can reach out to Practice Match and we will be happy to provide you with mentorship and guidance. Now let's learn more about physician immigration. Please note that microphones will be muted throughout the presentation. If you have general questions, Elissa will try to cover them in her presentation. If there's anything that doesn't get answered here, or if your question is personal or specific to you, Elissa will share her contact information at the end of her presentation so you can reach out to her. Elissa Taub is a partner in the immigration law firm Siskind, where she leads the firm's healthcare immigration practice. She handles numerous matters for physicians, including J-1 waivers, H-1Bs, and green card applications. Elissa is the co-author of the Physician Immigration Handbook. She's an active member of the American Immigration Lawyers Association and has served on several national committees. She's also a leader within the American Health Law Association. Elissa earned her law degree from Villanova University School of Law and her bachelor's degree from Washington University in St. Louis. It's my pleasure to introduce Elissa Taub.
Hey, thanks so much, Ashley, and I'm happy to be with you all here tonight. As is pretty evident from the name of this webinar, we're going to talk a lot about J-1s and J-1 waivers tonight. Hopefully, most things that you'll need to know as you navigate a job search and you're in potential need of a J-1 waiver and learning more about that. So let's dive right in. We have a lot of ground to cover. And I should mention, I'll monitor the chat. If I see, I will try to, monitor it periodically so that if I see a question come up, I can answer it in the course of what I'm talking about. If I don't get, as Ashley mentioned, if I don't get to your question tonight, or if you have like a personal immigration advice question where this public forum is probably not the best place to confidentially discuss that, I'll share my contact information at the end. You can always go to our website and schedule an appointment or email me and we can discuss that way as well. Without further ado, let's dive right in. So if you're here on this webinar, chances are you're on a J-1 visa. And I thought the best place to start before we talk about waivers is to talk about what in the world is a J-1 visa, just to kind of set the scene, give us some context for what we're about to discuss. The exchange visitor program that was created back in the 1960s led to the development of the J-1 visa. When you come to the US on a J-1, the idea of this visa is that you are fostering cultural and educational exchange between the United States and other countries. It's definitely a unique visa status. It's not the kind, it's very different from like an H-1B or an O-1 where an employer might just sponsor you, you go to the embassy, you apply for your visa and you come into the United States. There's more of a process involved in the J-1. For the first thing, if you're here on a J-1 for a medical residency or fellowship, chances are, or actually not chances are, it definitely was sponsored by ECFMG. ECFMG is the only Department of State authorized sponsor of J-1s for medical doctors who come to the United States to engage in a residency or fellowship. That's really unique, right? There aren't any other non-immigrant visa statuses that require there to be a sponsor like that. And the hospital where you're probably doing your training is considered to be a host site. So you have ECFMG sponsoring you to participate in your program at a host site. And there are requirements that each of them have to meet with the US government in order to be recognized as host sites and sponsors. There's really no other visa that kind of has this kind of framework for managing it. In addition, when you are ultimately issued your DS 2019 and you're ready to come to the United States, as you all know, you don't apply to USCIS first if you're outside the United States. You can apply directly at the embassy for your visa. Something that's also very different from H-1Bs or O-1s where you need petition approval from USCIS before you can get the visa stamp. But probably the most important thing to know about the J-1, and the reason why you all are here tonight, is that that many J-1s have attached to them this 2-year home residence requirement. And in fact, every physician who comes to the United States on a J-1 is subject to this requirement. In a normal J-1 presentation, I might spend some time talking about who is subject, how to determine whether you're subject to the home residence requirement. Sometimes there are questions about that. But tonight, because our focus is on J-1 waivers for doctors, we're going to assume everybody is subject to the home residence requirement because every physician who comes to the United States for graduate medical education on a clinical J-1 is subject to the 2-year home residence requirement. You may sometimes hear lawyers refer to this requirement as 212E. 212E is the section of the Immigration and Nationality Act that creates this requirement. So if you ever see or hear reference to 212E, it's just referencing the section of the law. It's all the same thing. What is the 2-year home residence requirement? Well, I'm glad you asked. What the 2-year home residence requirement says is that at the conclusion of your J-1 program, the US government assumes or expects that you are going to return to your home country for 2 years. And unless you do that, or you get a waiver of that requirement, you have several limitations on your immigration pathway in the United States that are really, really important. First is you cannot obtain an H-1B visa. And when I say visa, I mean the visa stamped in your passport. We will talk about Canadians in a little bit who don't need visas, but the prohibition is on getting an H-1B visa stamped in your passport. There's also a prohibition on getting an L stamp in your passport. Doctors really don't get L visas, so we're not going to really focus on that. You can't obtain a green card until you deal with the J-1 home residence requirement. And in most instances, you can't change status from J-1 to any other status in the United States without specific types of waivers. So your immigration pathway is really limited. You know, what you can get without a waiver is an O-1, right? Because that's not on this list. If you open your own practice and you're from certain countries that the US government has treaties with, you might be able to get an E visa. There may be, you may be able to switch to an F, as a student. So there may be other visa categories that are available, but no H-1B, no green card until you either fulfill the home residence by going home or you get a waiver. It's key to understand that nothing else will dispense with this requirement. Not time, not switching to another visa status, not marrying a US citizen, not marrying a green card holder, nothing really other than fulfilling it or getting a waiver. So that's really it. It's very easy when you think about it like that. There's really no other way to dispense with the requirement. Before we dive into waivers, though, let's talk a little bit about what it looks like to comply with the home residence requirement. More and more physicians that I speak with either are at the tail end of complying with the home residence requirement or are seriously considering it as part of their job search. There are a few key questions that we need to answer when a doctor is planning to fulfill the home residence requirement. First question is, what is your home country? Now, for many of you, you're like, why is that even a question? I know where I'm from. But for some people, it can be complicated because you might be, your home country by law is your country of citizenship or your country of last permanent residence at the time you obtained your initial J-1 to come to the United States. If you look on your DS 2019, there's a country listed on it, and that's the country we're talking about. Where did that statement of need come from when you first came to the US as a J-1? It might not have been your country of citizenship. It might have been the country you were living in for medical school. Are you able to return there? Is that even a possibility for you? For some physicians, it's not, and that can complicate plans to fulfill 212E by going home for 2 years. So it's very important to understand that the question about what's your home country could be an issue. That would be a situation where I would recommend consulting with an immigration attorney. It might be possible to file for something called an advisory opinion with the Department of State to see if they can provide clarification, or it may be something where later on, you go to what you believe is your home country for 2 years and then try to argue it out with the immigration service on the back end to say, I fulfilled this. So there could be a variety of different ways to deal with a discrepancy about what your home country is. But, sometimes those issues can be complicated. You must reside in your home country for 2 years, right? It is the home residence requirement, not the home take a trip there every so often requirement. Also, if you're from Europe, for example, if you're from Germany or Belgium or France, spending time in any EU country doesn't cut it. You actually have to be in your home country, not near your home country, but actually there. Short trips outside your country, outside your home country, short trips to the US, those are allowed during those 2 years, but you're going to want to make sure that you have spent the full number of days that you need to add up to 2 years in your home country before you try to, claim that you've complied with it. I know right now there may be some folks who might be Ukrainian who decided to fulfill the home residence requirement and maybe weren't there for the full 2 years, and now they're seeking to come back under different circumstances. I think, in those situations, you would want to seek individual immigration immigration consultation. Those issues can be a little bit complex. And so, I'm not going to specifically talk about that tonight, but there's another issue where, there could be complications due to conditions in your home country that were unexpected at the time that you decided to go back and fulfill. If you decide you're going to fulfill the home residence requirement, maintain strong documentation that you have spent the full 2 years in your home country. What might that look like? Well, you have a passport that is going to have stamps in it. You want to be able to connect the dots for an immigration officer to show, like, I entered my home country on date X and I left on date Y. Maybe there's 2 years in between those two dates. That could be helpful. In addition, if you're working during those 2 years while you're in your home country, you should have pay records. You may have utility bills. You may have proof of doctor's appointments, receipts. If you're in a place where you're commuting every day, you might have toll receipts that show that you were commuting back and forth. There are lots of different ways to document that you've been somewhere for 2 years. The most important part of this for me is that you plan for this at the time that you return home. It's much easier to have a plan for what type of documents you're going to keep during those 2 years than to be home for 2 years and at the end say, oh, oops, I need to come up with the documentation that I've been here for 2 years. That could be a lot harder to gather together. So it's just important to plan for that. And the last thing I want to talk about on this slide is Canadians. I'm sure there are some Canadian citizens on this webinar. I get asked a lot about, okay, I know there's a thing, so let's talk about it real quick. I'm going to go back to the last slide for a second. You'll notice here, the first bullet point there says that if you do not fulfill the home residence requirement, you cannot get an H-1B visa. And the word visa in that sentence or in that phrase is really, really key. That is a legal term. And in the law that sets forth the home residence requirement in 212E, it specifically discusses that there is a prohibition on obtaining H-1B visa or H visa. Canadians do not need visa stamps to enter the United States. Canadians, once you have an H-1B approved, it's not required for you to go to a US embassy and apply for a visa to be stamped in your passport. Instead, you have your H-1B approval notice from USCIS, and you can come directly into the United States with that approval notice without having to take any further steps. Therefore, Canadians aren't prohibited by 212E from entering an H-1B status. That there's like a little exception or loophole in the way the law is written. It wasn't specifically done to help Canadians, but the operation of the law provides a benefit to Canadian citizens. There are a few ways that this can be helpful for Canadians. One is, let's say you find a job in a state and there are no more J-1 waivers available for that year. Potentially your employer may be able to file an H-1B for you and then apply for the waiver the following year. It does require that you make a trip up to Canada to turn around, show your H-1B approval at the border and come back in, because you won't have a waiver to facilitate a change of status. But it allows you to get the H-1B before the waiver. The other way that this can be helpful is, sometimes you have folks who find jobs, in border communities in the United States. And we'll have Canadian citizens who might live in Canada and spend every night there and really, conduct their lives and reside in Canada for 2 years while commuting into the United States every day on their H-1B to work. And in that way, you can fulfill the home residence requirement by living in Canada. One thing I want to mention, though, is if you're not one of the people who's going to be using that border strategy by what some people refer to as sleeping in Canada, if you're not going to use that strategy, and let's say you're in the interior part of the United States, you're in Missouri or Illinois or wherever it is, away from the border, and your employer says, okay, we're happy to apply for an H-1B for you before you get the waiver. Come on, we'll make it happen. That's great, but getting the H-1B first does not negate the need for the waiver, because what did we talk about? The only way to deal with the J-1 stuff is by going home for 2 years or getting a waiver. So getting the H-1B first does not take that away, right? It's not one of our two scenarios. So you still are going to need a waiver. And I recommend that as you're talking with an employer, if they're going to take that tactic for you, to really find out what's the plan, right? When are we seeking a waiver? What type? How is that going to work? Make sure you're taken care of in that regard so that everybody's on the same page and you understand, what the expectation is. But that's basically the Canadian exception. I don't like to call it a loophole because it's not, but whatever you call it, that's the Canadian option. Okay. Let's talk a little bit about J-1 waivers now. So we talked about what's a J-1, what's the home residence requirement. If I decide to fulfill the home residence requirement, what does that look like? And now we're finally get to the waiver part. Yay. I'm gonna, on this slide, list a bunch of types of J-1 waivers. I'm gonna go over them. Generally, on the ensuing slides, we're gonna get a little bit more specific, especially about the underserved area waivers. We're gonna go into good detail there and talk about and compare and contrast the different types of waivers. So you can kind of get an idea as you're making decisions one way or another, what the consequences of those decisions might be. So the first type of waiver I'm going to mention, and I'm listing it first because we're going to spend almost no time on it, are HHS research waivers. Now, going back 10 or 15 years, this was a great tool. We would use them for people who were in academic positions doing research, whether physicians or not. And it doesn't have to be bench research. It can be clinical research. But this would be for physicians who are working at a really high level at an academic institution where you're participating in high level research and your participation is essential to the continuation of that research program at the institution. They're different than O1s. It's not an extraordinary ability standard. It's an essentiality standard and showing that this research is really important. The reason we're going to spend almost no time talking about these is that right now, HHS research waivers are taking over 3 years, at or over 3 years to be approved by HHS. And then they still have to go through the other steps of the process. So for this reason, for those of you who are in residency or fellowship right now, this is not something that you would even apply for probably coming out of fellowship. It would be something that you would do later on in your career, maybe An academic institution would sponsor you for an O1, you'd work a number of years, and then eventually they'd apply for this kind of waiver for you. So we're not going to spend a ton of time here, but it exists. And I want to make sure that I mention it as a potential option out there. Hardship waivers. A hardship waiver is a waiver that an individual can file to show that complying with the home residence requirement would pose exceptional hardship to a U.S. citizen or green card holding spouse or child. So you have to have a qualifying relative to apply for a hardship waiver. Hardship waivers can be really useful in some circumstances. I like them best where the J-1 is married to a U.S. citizen or permanent resident, because they can immediately, upon approval of the waiver, you can go immediately to green card sponsorship. And you don't always need to have like an intervening H-1B or O or something in between. Right now, one of the biggest challenges with hardship waivers is the processing times. Not only is USCIS taking close to a year to approve these things, but then when they get to the US Department of State, they're also taking upwards of 10 months in some cases to approve hardship waivers. So you're talking like 2 years of processing. That's not typical, right? That's not usual historically, but it's what's happening right now. So, I sometimes work with physicians who've already filed a hardship waiver. They find a job with one of my clients in an underserved area, and sometimes we'll say, look, we can get you an underserved area waiver. Like, it's not a big deal, right? You're in an area that's covered by a federal agency. We can get as many waivers as we want, whatever the case might be. Withdraw that hardship waiver. Your Conrad 30 waiver or DRA waiver or whatever it is going to be long approved before you ever hear back on that hardship waiver. So sometimes it's just not practical at this point to do hardship waivers. But there are other situations where the hardship waiver is like the best option. So I don't, we'll talk in a couple of slides about kind of pros and cons and comparing all these different kinds of waivers. And sometimes it can be a really good option. So I don't want to scare you with the timeframes, and hopefully they'll continue to improve. But they can be really, really helpful. I did a hardship waiver a couple of years ago for a couple. The husband was from South America. The wife was American, and they had a little baby, and the wife was doing really important research and important work at an institution of the US federal government. And we were like, she has to go with her husband back to his home country for 2 years. That's going to actually be a problem for our country. So we had a really strong argument in that regard. And we had some other arguments as well, based on the baby and everything. And that was approved relatively easily. So there are some cases where hardship waivers just make a ton of sense. Similarly, persecution waivers, I put them in kind of the same bucket because they operate the same way, even though the standards are different. Persecution waivers are available if you can show that you would be persecuted in your home country on account of some protected ground like race, religion, political opinion, that sort of thing. It sounds similar to an asylum case, but there are some key differences. First of all, you have to show you would be persecuted, not just that you have a fear of it, but also if a persecution waiver gets approved, you have a J-1 waiver. You don't have asylum. You don't have any other status. You just have the approved persecution waiver, which can be very helpful, right? For some folks, this is a really strong option. You don't need to have a qualifying relative like you do for a hardship waiver. So even somebody who's single, who might qualify for a persecution waiver, could seek that, where if you're single, you can't file for a hardship waiver unless you have a US citizen or green card holding child. So differences between the hardship and the persecution waivers, but in the right circumstances, they can be really, really good tools to use to get a waiver without necessarily having to work in an underserved area and without having an employer lined up at the time you apply. And then finally, we have, and I have a typo on my slide. That should say based on working in an underserved area for 3 years, not 2 years, but it should say 3 years. And that's only for physicians who are on J-1s. And on the next few slides, and as we go through, we're going to talk more in depth about the underserved area waivers. And I'm going to get off this slide so I don't perpetuate my typo. So how did the J-1 waiver process work? Regardless of what type of waiver you apply for on that prior slide, the waiver is going to have about 5 steps. The first step is to file something called a DS 3035 with the US Department of State. This is essentially a waiver application. It opens a file for you with the Department of State. It assigns a case number to your case that's going to follow it until it gets to the last few steps. This is a key part. Now, if you're working through a lawyer, your lawyer is going to file this for you. So don't go out and run out and look it up and say, oh, I have to file this application. You do not. It will be filed for you as part of your waiver application. But that is the first step of what gets filed. And this is really personal to the physician. Your employer doesn't file the DS-3035 under their name. It's filed under the physician's name. And there's some key aspects of that DS-3035. The second step, and sometimes step 1 and step 2 are done at the same time, is to file the waiver application with the relevant government agency. So if it's a hardship waiver, you're going to file a form I-612 with USCIS with all of your supporting documentation to show why you are eligible for the hardship waiver, or the persecution waiver operates the same way. If you're applying for an underserved area waiver, step 2 means that you're going to be filing a waiver application with the agency you're asking to sponsor your waiver, whether that's going to be the Conrad 30 program in your state or one of the federal agencies that supports those waivers. Again, if you're working with an employer or a lawyer, they're going to handle that step for you, but that's going to be step 2. Step 3, the government agency is going to review the application and hopefully they're going to make a recommendation to grant your waiver. Now, sometimes when you apply for a hardship waiver or a persecution waiver with USCIS, they might issue a request for evidence as part of that, right? But just big picture wise, the next step is that the government agency you've asked to support your waiver recommends it. And they send it on to the US Department of State, where it matches up with the case file that we established in step 1. The Department of State is going to review your waiver application, and then they're going to recommend it to the Immigration Service. Now, again, this is where with hardship waivers, step 4 is taking almost a year to get through. With Conrad 30 and underserved area waivers, usually somewhere around 8 weeks. Sometimes it can run as long as 12 to 16 weeks at busy times of the year. This year, we've been holding pretty steady around 8 to 12. Things have been moving. I know that sounds like a long time. Things have been moving pretty well on those this year. During the height of the COVID pandemic, the Department of State was virtually at a standstill. We are past that. They are actually doing pretty well right now. Knock on whatever my desk is made out of, that will continue because things like our waivers are just getting through the system right now, which is great. When the Department of State recommends your waiver, they're going to send it to USCIS, and then USCIS ultimately will approve the waiver by issuing an I-797 approval notice. If it's a Conrad 30 or other underserved area waiver, behind that approval notice is going to be 3 white pages that say informational at the top. And that's what says where you're supposed to complete your waiver service. And that whole packet, the green I-797 and the informational pages all together are considered to be the approval notice. If we're talking about a Conrad 30, really almost any waiver, once we get past step 3 and we're at the Department of State, we can kind of take a little sigh of relief. We feel pretty comfortable our waiver is going to be approved from that point out. It's just a matter of time till we get through steps 4 and 5. On some hardship waivers, if there's some, sometimes there can be a controversy. You might have had Fulbright funding, which can really complicate a waiver application. There may be some other reason why the US Department of State might have diplomatic objections to granting your waiver. So sometimes in hardship or persecution waivers, that Department of State analysis, is very important to wait for. In my Conrad 30 and other underserved area waivers, the Department of State typically approves those without any further pushback. So, like I said, steps 4 and 5 typically happen. You just need the time for them to happen. I put step 6 in parentheses because after the waiver, what does the waiver get you? The waiver makes it so that you don't have to go back to your home country for 2 years to be able to continue your immigration journey in the United States. It doesn't actually give you any authorization to stay here. As I like to put it, it means you don't have to go home, but it doesn't necessarily mean you can stay here. So post-waiver approval, the next step is figuring out how to keep you here in the United States. Did you file a hardship waiver based on marriage to a US citizen spouse? Are they going to sponsor you for a green card? Is your employer, if you went through an underserved area waiver, or is your status changing from J-1 to H-1B? Is there some other status, like O1 or something that you're going to switch to because maybe you have a more complicated immigration history and we have to look for some other options. So depending on the type of waiver and your own personal circumstances, step 6 might look a little bit different. But there is, more that happens after the waiver because the waiver is not a status. You will never be in J-1 waiver status. If you're an underserved area waiver physician, you might be working in H-1B status in fulfillment of the J-1 waiver obligation, but you're never in J-1 waiver status. That is not a thing that exists. I say this because I hear from people all the time, well, I'm in J status, or I hear it from physician recruiters who will say, I have a doctor who's on a J-1. And I'm like, no, if they're attending physician, they can't be on a J-1 or they're working for you illegally. They're probably in H-1B status and you got them a waiver. It's a really important distinction to make. And so that's why I'm kind of saying it like that. But I want you to understand as you go through this process, as you get to each one of these steps, kind of what it means to have an approved waiver. It's really important, but it's not the end of the story. So this is like one of my all-time favorite slides. This comparison between shortage area waivers and hardship and persecution waivers. I don't know why, for some reason, I just really like it. And I think it's, let's go back. I think it's really useful, or I hope it's really useful. To compare and contrast these two types of waivers that are the most common waivers that doctors talk to me about every day, some of the things that you might think about as you were deciding whether to apply, sign a contract with an employer who's going to sponsor you for an underserved area waiver, or say, I don't need that. I'm going to take care of this myself. I'm going to apply for a hardship waiver based on my relationship with my spouse or my child. Both valid positions, right? What does it mean to make that decision? So under shortage area waivers, you see the first bullet point. Once that waiver is approved, not only can you change status in the United States from J-1 to another status, you must change status from J-1 to H-1B. There is no requirement that you travel abroad to obtain an H-1B visa before you start work. I would say 99.99999% of the physicians that I work with stay in the United States through that whole process. You don't have to. If you want to travel over the summer back home, visit family, then come back on your H-1B, that can be worked out. But if you're not planning to travel and you're just like, you want to be in the United States for this whole process, the shortage area waiver is going to facilitate that. Hardship and persecution waivers do not have the same benefit. There is no mechanism in the law to ask for a change of status from J-1 to anything else other than a green card through approval of a hardship or persecution waiver. Stated differently, if you have approval of a hardship or a persecution waiver, you have to leave the United States to apply for a visa stamp before, in O or H status or whatever it is, before you start work. And the only exception to that is if you're sponsored for a green card right away. So hardship waiver is approved, next day, your adjustment of status application is filed. Okay, that's different. That's the exception. Shortage area waivers. Physicians who obtain waivers based on working in an underserved area are exempt from the H-1B cap for their lifetime. Now, I'm not going to spend much time today talking about the H-1B cap because it's outside the scope of this presentation, but suffice to say that doctors who get underserved area waivers never have to worry about whether their employer is for-profit or nonprofit or has any academic affiliation. You never have to worry about going through a lottery to get an H-1B to work for any employer, whether during your waiver or after your waiver is complete. Same is not true for hardship and persecution waiver recipients. They are treated like any other H-1B applicant. So the H-1B cap applies there. So if you're looking to take a job with a private practice and you have a hardship waiver approved and you don't have a spouse who can sponsor you for a green card and you need H-1B sponsorship or some other sponsorship to be able to work there, that's going to be a key consideration about whether the hardship waiver was the right avenue for you to get a waiver. It's a really, really important thing. You really limit who your employer might be. Now, if you might be O1 caliber, you've got extraordinary ability in your field, you've got publications, other achievements, maybe you don't care about this, right? You're like, oh, my employer is going to sponsor me for an O after my hardship waiver is approved. I'm doing that for a physician right now. Well, that's great. But That's not 100% of the physicians out there. So it's important to understand this limitation. On the other hand, when you get a shortage area waiver, you have to serve all 3 years in the underserved area before you are eligible to complete green card processing. Your employer can start the green card process for you while you're in your 3 years of service, but under no circumstances, not through any mechanism, are you going to receive a green card before the 3 years are up. Even if you marry a US citizen, still have to wait till the end of the 3 years. If you obtain a hardship or persecution waiver, there's no 3-year commitment. You're immediately eligible to apply for a green card. Now, of course, all the usual rules about that apply. If you're from India and you're not applying for a marriage-based green card and you're going through your employer, you still have a backlog, right? So like this doesn't take that away. It just means that the J-1 isn't going to be an obstacle to you applying for a green card at that point. And the final thing is that under shortage area waivers, you have to have a job to sponsor you. You have to sign an employment agreement before your waiver can be filed. That is an absolute requirement. You can't just dip your toe in the water and say, hey, let me see if I can get this waiver approved and then I'll sign my contract. Not the way it works. But for hardship and persecution waivers, it has absolutely nothing to do with your job. You can apply before you ever even have an offer. And that's fine. You can take care of that whole process by yourself without an employer needing to be involved. For some people, that's really attractive to be able to take control of your own immigration process. So that's a big distinction. All right. There you've got a little bit, compare and contrast the two types, most common types of waivers that physicians seek, and understand, that there could be really, important consequences to one decision or another. So somebody asked whether applying for a hardship waiver during residency might risk losing their J-1 status while they're in training or not getting an extension for fellowship. And, this is a big issue, right? Typically, doctors are going to look to apply for their hardship waiver after they get their last DS 2019, because the application for the waiver can complicate getting an extension for another year to actually continue participating in clinical training. And this is where some of these processing time issues on the hardship waiver can be really challenging to navigate, because you might apply for a waiver like now, thinking, okay, well, it'll be approved over the course of the next year. My spouse can apply for me for a green card. I'll get an EAD, like whatever it is within X time frame. And then it's like months after that, and you're still waiting because the government processing times are so long. So yeah, you wouldn't lose your existing J-1 status by applying. So you would definitely apply before you finish your training, but it can complicate getting an extended DS 2019 to continue participating in a clinical program. So that's an important question, an important issue to be aware of. All right, back to the slides. All right, so let's talk about underserved area waivers, and we'll do a little bit of a deep dive on these because they're just a lot of issues. So we'll talk about travel during the J-1 waiver process in just a minute. There's another question that just popped up, and the timing of the travel is actually the most important thing. Typically, I recommend that if your case, especially if it's a shortage area waiver, once your case is sitting at the US Department of State, I really don't want you to travel abroad until the summer, when you can maybe come back, travel and then come back using your H-1B and apply for the H-1B visa. Once your waiver is approved by the Department of State, it can complicate getting a J visa. And so if you're going to need to consular process, like I'd want you to do that. You can be outside the US when a waiver is filed. You can be outside the US when that initial agency is considering your waiver. But once you're at the Department of State, that's the cue in my head, like, might want to dial back travel plans at that point. There are reasons why things can get particularly complicated at that point. But then once your waiver is fully approved and you finish your residency or finish your fellowship, if during the month of July or whatever it is, you're like, I want to go back, I want to go home, I want to spend some time and visit before I start my job. Well, if you can then apply for your H-1B visa stamp abroad, you can come back on that H-1B and then start work. And I don't have any problem with that. That shouldn't complicate anything. All right. Let's talk about these underserved area waivers. So as we talked about before, the essential basics of these waivers is 3 years, full-time, underserved area. That is what your contract the essential terms of your contract are going to be. The most common program that you've probably heard of is the Conrad or State 30 program, where each state Department of Health can approve up to 30 waivers for physicians in a given federal fiscal year. The federal fiscal year starts every year on October 1st, and it extends through September 30th of the following year. So for these purposes, we've been in 2022 since October 1st of 2021. So that's the year. We're not talking about calendar year. We're talking about fiscal year. You also have several interested government agencies. These are agencies of the US federal government that can approve unlimited waivers. So state 30, 30 per fiscal year. Federal agency can do as many as they want. I listed them all out here. I'm going to go through really quick and just tell you what they are. The DRA is the Delta Regional Authority. The ARC is the Appalachian Regional Commission. Each of these agencies covers a specific geographic area of the United States. So if you're out west, sorry to say, there's no geographic federal agency that covers the western part of the US. The DRA is the Delta Regional Authority. It covers the Mississippi River Delta region from this really bottom of Missouri and Illinois through parts of western Kentucky, West Tennessee, eastern Arkansas, western Mississippi, a good portion of Louisiana, and some of Alabama, which isn't by the Mississippi River, but somehow got its way into the DRA. The ARC covers a large swath of the United States from northeast Mississippi through parts of Alabama, Georgia, the Carolinas, Tennessee, Virginia, West Virginia, I think maybe a smidge of Maryland, Pennsylvania, and New York. They also do, both of those agencies, unlimited waivers for specialists and primary care physicians. There are lots of opportunities. Now, they each have their own particularities, right? They each have their own requirements, which we'll talk about in a few minutes, but those could be really, really good options in some locations. HHS, we talked about their research waivers earlier. They also have a clinical waiver program that is available to primary care physicians or hospitalists who will work in an underserved area that has a score of 7 or higher. It's a primary care HPSA. That's the type of underserved area that has a score of 7 or higher. The physician has to work in outpatient primary care or hospitalist work and must start work within 1 year of completing residency. That means that if you have more than 1 year of fellowship, you will not be eligible for an HHS waiver, even if you say, I'll do outpatient internal medicine. It won't fly. It's a regulatory limitation. That program is national. So you can be in California working as a hospitalist with, maybe you did an internal medicine residency, no fellowship, get a job as a hospitalist in an underserved area, score of 7. You can get an HHS waiver. You don't even have to touch Conrad 30. So it's a really phenomenal program. It moves through pretty quickly. I have been filing, the program expanded in May of 2020 to its current rules. And since that time, we have been filing a boatload of those waivers. They're really fantastic. The VA, the Veterans Affairs Administration, has its own waiver program that is administered in-house. The VA is not allowed to engage immigration attorneys in those processes, but physicians may, and sometimes do, to kind of help oversee the process from the outside. But the VA handles all of that in-house. I think the VA is a wonderful institution. My father is actually a VA patient. I think they do great work. Their waiver program has some issues. It's a little slow. They really can't start the process until January of each year. So some physicians can get a little frustrated with it, but it can be a really good option in the right circumstances. And then I can't go into too much detail, but there's a potential new option where there's a new federal agency that is in the process of creating a brand new federal agency program that is going to cover parts of the southeastern United States. And that's about all I can say about that. You will be getting more information about this over the next month or so. The plans are like very, very advanced. Our office has been providing some advice on this, but I'm not at liberty to provide any more information about it. And so I don't ask. But I promise more information will be coming soon. You will not be able to miss it. I think there'll be a lot of fanfare with this rollout. So stay tuned on a potential new waiver option coming soon for the fall. Okay, those are the types of programs that are available with underserved areas. How do these things work? So here are the basics. This is going to be the same no matter what. As I said, 3-year full-time employment agreement to work in a primary care HPSA or MUA, or sometimes even an MUP. HPSA stands for Health Professional Shortage Area. MUA stands for Medically Underserved Area. MUP stands for Medically Underserved Population. You have there the website that you can use to look up an address and see if it's underserved. Even if you're a specialist, you are looking at the primary care HPSA. Just ignore the fact that it says primary care. However, when you go onto that website and you plug in an address, you're also going to see dental HPSA and mental health HPSA, and those you want to ignore like they don't exist. Primary care HPSA, MUA, MUP. We'll talk on the next. Some states, some programs may limit which one of these you can use. So it's not the same everywhere. You'll hear me say that a billion times throughout the rest of this presentation, but those are the types of underserved areas you're generally looking for. Your contract is going to define full-time as 40 hours a month or 160 hours, 40 hours a week or 160 hours a month. There are a couple of states that want to see 2,080 hours a year as an alternative. Typically, this is not going to include call, travel, research, or administrative time. It does include things like charting and patient transition from one provider to another, things like that. Anything that is considered patient care is covered in these hours, but anything that would be more administrative, teaching, that sort of thing, like classroom teaching, typically not included in the 40 hours. And also your contract is going to have language that say that you agree to start work within 90 days of when USCIS approves your waiver. Every year I get a million questions from doctors whose waivers are approved in like December, January, that they can't start within 90 days and they're freaking out. You have complied with the requirement by agreeing in your contract to start work within 90 days of waiver approval. Obviously, if that's not practical or not legally possible because you're still in a residency and you're not even licensed yet, nobody can make you start work within those 90 days. It's okay. That's not going to be, it should not be a problem into the future as long as you've made the agreement in your contract. All right, these are the things that stay the same. And now for the things that vary. And I already told you, you're going to hear me say it a billion times, every program is different. If you apply for a waiver in Illinois and your best friend applies for a waiver in Missouri, it's different. If you apply for a waiver through the ARC and your best friend applies for a waiver in Arizona, it's different. It is different, different, different. Everything is different other than the things I just told you. How they treat primary care physicians versus specialists could be different. Indiana, strong preference for primary care. Same in California. Some states, they don't really care. Or they do care, but they get so few primary care applications that their preference for primary care doesn't matter. It's different. Flex waivers. Let's talk about those for a second. A flex waiver is a waiver. It has nothing to do with specialists in most places. Under the law, a flex waiver is available to a physician who's not going to work in an underserved area, but who the facility that you're working at attracts patients from underserved areas, sometimes in certain percentages or numbers. Every state has discretion to use up to 10 of their 30 flex waivers, or their 30 waivers for flex. Let me say that again. Every state has discretion to use up to 10 of its 30 waivers for flex. Not every state uses them, like Texas, Missouri, they don't use flex waivers. Indiana, I don't think uses flex waivers, but like New Jersey, they'll do as many as you can give them. Kentucky uses all 10 every year. Arkansas uses all 10 flex every year. There are some states that use them in big numbers. Every state's different, right? The threshold percentage of the underserved patients in order to qualify for a flex waiver is different. I looked up today, Massachusetts. They've got like 5 different ways you can qualify for a flex waiver. There's not even one standard. So even within Massachusetts, it can vary who qualifies for a flex waiver. Your filing deadlines. I hear every year, I need to apply on October 1st or I'm not going to get my waiver. Everybody's telling me I have to apply on October 1st or I'm not going to get my waiver. And there are like 2 states where that's true. Maine is sort of one of them. It may matter if you're going to Washington State and you're a specialist. Initially, they'll only do 10. You want to apply on October 1, right? By and large, October 1 is not a deadline in most places. October 31st is a deadline in lots of states. In Illinois, Kentucky, most years, Michigan, you have to apply in the month of October. Missouri's like that. Some states have 2-week filing periods. Florida, Connecticut, Texas actually opens in September. Georgia only opens for the month of August. It's earliest in the nation. You get the point. Filing deadlines are different. And I should also mention the processing is different. So like I might apply, one state might be first come, first serve, like Virginia, or I might apply in New York and they'll accept all of the applications that are submitted between October and the end of November, and they don't make decisions until like now. It's a long slog in New York. So even that's different, you know, even after you apply, when you're going to hear back from the state, that's going to be different depending on what program you apply to. Every program requires you that your employer provide proof of recruitment. This means they want to know what your employer did to try to find a doctor that didn't need a J-1 waiver. The DRA and the ARC have like really specific recruitment requirements, almost like absurd ones. HHS, you just have to show that you recruited at all. And that's how a lot of states are. So that can be different. In some states, they just want a letter saying you recruited and describing it. Other places, they want like copies of everything you did to recruit. So that can be different. That's not something that you as the physician are going to have to provide. Your employer does, but you need to understand that like when your immigration lawyer says they're still working together with your employer to develop all the documents that need to support the application, these are the kinds of things we're talking about. They also oftentimes have to come up with some data. What's their payer mix? Medicaid, Medicare, self-pay, insured, uninsured. Where are their patients coming from if it's a flex waiver? Lots of data goes into these applications. And sometimes, you know, it takes an employer some time to mine the correct data so that we can actually put the application together. Every employer, almost every program also requires an employer to have a sliding fee scale or charity care policy. If somebody comes to the practice and says they can't afford to pay for their care, you can't turn them away if you have a J-1 doctor. You have to be able to provide them some sort of charity care policy based on their income to be able to provide them a discount for their care. That's what this is. Every employer's got to have one. Some employers say, we do it, but we don't have a policy. Guess what? It's time to write one. That can take some time in the preparation of the application. And also your employment agreement, the terms are going to vary from place to place. And we'll talk about that on the next slide. So what can vary in your contract? All of these things. Can you have termination without cause where your employer can terminate you with 90 days notice for any reason? Maybe, maybe not. HHS waivers, there has to be a statement in your contract that says termination may only be for cause for the initial 3-year term of your agreement while you're completing your waiver. That's an issue, right? Your employer's got to may need to expand the definitions of what for cause termination is in order to have that available to them during the initial 3-year term of your contract so that you're not on the hook with a for cause termination when really it's their financial issues that are causing you to be laid off, right? We've got to figure out exactly how to word all of that. Non-competes. Most programs do not allow non-compete clauses. Not every program though. Indiana allows them if they're reasonable, which is actually what the law is. So it's not a federal prohibition on non-competes. It's just that most programs don't want them because if they're going to issue you one of their coveted 30 waivers, they want you to be able to stick around, even if you're not with that particular waiver employer. So that's why the non-compete prohibition comes up so much. Every location has to be listed in your contract by name and address. Some states don't want to look at it if you have any non-underserved areas on your contract. The requirement is that you need to work full-time in the underserved area. Under the federal law, it doesn't matter if you have some like PRN locations that aren't underserved. Some states don't want that. They only want to see underserved locations in your application. That can vary. What happens if you're going to work in more than one state? Is Illinois going to provide you with one of their 30 waivers for you to work half your time in Missouri? Probably not. Some things to consider as you go through this process. Does it matter how your salary is listed? Can it be annual? Can it be hourly? Does it have to be one or the other? Virginia and New Mexico are two states that require you to have a full annual salary guaranteed in your contract, no hourly rate allowed. Can you have liquidated damages in your contract? Must you have liquidated damages in your contract? Does it not matter? That varies. Liquidated damages are a set sum. So if you breach your contract by terminating early, your employer can say, hey, that damages us. We need to recover from you X number of dollars because we're not really sure exactly what it would cost us to get back all the damages that you created by leaving early. That's what liquidated damages does. Whether you can have it, whether you must have it, what the amount might be, anybody's guess. Sometimes there's other required language. Some states like Ohio want you to, or Maryland, want a statement in the contract that the contract can't be terminated without approval of the state, or not terminated, can't be amended without approval of the state. So there may be sometimes other required language that has to be thrown into your contract. The last thing I want to cover really quickly, because we're running out of time, there's one question here I want to answer, but let me run on to the last slide. So once we get through this whole process and your underserved area waiver is approved, the US government assumes that you are going to work for that employer for all 3 years that you've committed to. Sometimes stuff happens though, and you need to change jobs during the waiver period. And it's important to understand that you can't just do that because you want to. You should not plan in advance. Okay, I can't get a Florida waiver this year, so I'm going to go take a waiver in Louisiana, and then a year from now, I'm going to go, transfer back to Florida. That's not how this works. In order to change jobs during the waiver period, and I'm going to skip a couple of things here. In addition to having a new contract for the balance of the period and finding another job in an underserved area, the most important thing is that there have to be some kind of extenuating circumstances that require you to make that change. Things like you're not getting paid what you were promised. You get laid off for no reason of, no fault of your own. The hospital might outsource to a staffing company, and so your employment changes to the staffing company. That's okay. That's extenuating. It could be any number of things. Sometimes a family member needs to move to another location. I worked with a couple of years ago where the husband was in the US military and he got moved, and we needed to move the wife to be with him. He had no control over that situation. Basically, what we're looking at is a situation that was unforeseen by you at the time you got your waiver and outside your control. That is essentially what we're looking at for extenuating circumstances. And it's a high bar. The Immigration Service doesn't approve everything. I mean, they're pretty reasonable on these cases, but it's a high bar to clear in some instances. And so if this is something that would apply to you, it's critical that you talk with a lawyer, that you be really open about what the situation is, and be able to provide documentation about what exactly is extenuating. During the pandemic, I worked with a couple. They were working in different locations. The husband was doing a fellowship in one state. The wife was doing a waiver in the other. And all through the first year of the pandemic, she flew to where her husband was every week, at great peril, getting on a plane during the early days of COVID. And she was living in this tiny little town on her own during a pandemic. And we were able to document a lot of the issues she was facing, and the Immigration Service approved that transfer. So there are lots of factual differences that can occur when we're looking at an extenuating circumstances case. So it's just important, if that's something that faces you, to get some individual advice about that. Make sure the situation you're facing might qualify. And there was one question here that I want to answer. Somebody asked, what is the maximum time off we could take prior to joining the waiver job after residency or fellowship? It's a good question. There's not really a specific limit in the law. my thinking is I want you to start as soon as possible. So for somebody who might finish their waiver job in June, or sorry, might finish residency or fellowship in June, your waiver is already approved. Maybe your H-1B gets approved, May, June, July, or, whatever. Your start date is September 1st. After the internal medicine boards, and you decide you're going to take off those, the 2 months in between and start work once the board exam is done. That's totally fine. I would say the overwhelming majority of my clients do that. If you're talking about taking off like 6 months before starting work, nobody's going to come knock on your door and say, hey, you're not complying with your waiver. But when you go to apply for your green card later on down the road and you're, and a USCIS officer looks at things, could that raise an issue? Maybe. I think, like I said, there's no particular rule. The main thing is, in terms of applying in advance for a waiver, you need to be in the fiscal year when you're going to finish your training. So, if you're PGY2, you're not applying for a waiver 2 years before you, well in advance of when you're going to finish your residency, right? Like that's not going to be considered. You've got to apply in the fiscal year when you're going to complete your training. And then, if you need to take some time off over the summer or something, nobody's going to really begrudge you that, I don't think. And then there's one other question here. Is it easy for Canadians? Is it easier to get an employer to hire you with an H-1B and then apply for the waiver the following year rather than compete for the Conrad 30? Well, either way, depending on the state and the location, you may be getting a Conrad 30 anyway, right? Like if you're going to work in Michigan, well, if you're applying this year, you're going to be doing Conrad 30. If you apply the following year, it's going to be Conrad 30. So that's not really the issue. But I think, like, for example, if you were a 2022 candidate, Michigan's long been full, right, since October. So there wouldn't be an opportunity to get a Michigan waiver right now to start in July. But your employer might be able to do an H-1B for you and then apply for the Conrad 30 in October. And we've had those kind of situations come up quite a bit, especially during the pandemic. Oh my goodness, 2020 was crazy for those kinds of things happening. For graduation in July 2023, when is the latest time to apply for a waiver? Well, to be honest, it depends on the program and the state that you're going to, right? Because we talked about all the deadlines are different. Here's my general bit of advice about timing. Best case scenario is that you sign a contract for a waiver job in the summer of your last year of training, maybe by August, September, depending on the state, right? If it's Georgia, you're going to apply for your waiver by the end of August. So that's a different story. But best case scenario is you sign a contract by sometime in the end of the summer, beginning of the fall, and you apply for your waiver in the fall. For some programs, that's required because if you don't apply in September, October, November, whenever the deadline is, you're going to miss out. If you're in a situation where the waivers are unlimited because you're going to file with HHS or you're going to file with the DRA or whatever it is, October through December, even into January, sweet spot for having a July start date. July 1 should be doable if you're applying within that time frame. If you're applying for a waiver February, March, April, your start date is going to be later than July, most likely, probably into August. The later you file in the spring, the later your start date's going to be in the fall, maybe into September or October, depending on the circumstances. I can file DRA waivers in June, and I've done that in prior years where there were, circumstances beyond the doctor's control that they didn't have a job lined up until the summer. And those doctors started work in the fall, November, December, somewhere around there. That's fine. DRA is never going to run out of waivers. So there's no deadline there. So I think, the fall is definitely your sweet spot for your first choice and to try to get through the process in a reasonable amount of time. But if you're talking about a situation where there are unlimited waivers, we're still filing them. I still have HHS waivers. There's one sitting on my couch back there right now, waiting for a review to be signed and filed tomorrow. So there's, and it's May. So, it's a complicated answer, but you can kind of see where I'm going with that. I think with that, I am going to wrap things up since we are just over an hour. I thank you all so much for your questions and for your attention. Oh, I didn't get to the last slide. There's my contact information. You've got our firm phone number, my email address, our website. You can always make appointments by going to the website and clicking on request a consultation. You can email me directly, happy to send you a link. Those are probably the two best ways. And I am not the only attorney in our office who handles physician matters. Megan Moody and Adam Cohen are also really great options. So if you go on our website and I'm not available for a little bit, look to Adam and Megan. They're really good options as well.
All right, Elissa, thank you so much for your time this evening and for sharing your expertise with all of us. I'm so excited to hear about this potential new option. Maybe that will be great content for a fall webinar.
Mm-hmm.
Thank all of you for attending as well. If you enjoyed this webinar, we have another one coming up on May 31st on physician compensation, knowing your worth and negotiating your contract. So we hope to see you all there. Good night, everyone.